First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good afternoon and welcome to the First District Court of Appeal. We have two cases on the docket today, and we will take them in the order in which they appear. First before us is Stephen Wottrell versus Kathleen Wottrell. Mr. Korn, you may begin when you're ready.
Thank you, Your Honor. May it please the court. I'm Michael Korn, along with Brian Roberts. We represent the husband appellant, Stephen Wottrell. I'd like to reserve 6 minutes, not only for rebuttal as to the main appeal, but also to address any potential cross appeal issues that may come up. Thank you, Your Honor. The issues raised on the main appeal both involve alimony. There was no question, but this was a permanent alimony case, the marriage being 20 years of duration. The problem here, as we see it, was the amount of the alimony awarded. The two factors that caused this amount of alimony award to be erroneous was first, the trial court's inability to actually make a determination as to the husband's net income and its reliance upon flawed data from the wife's expert. There was also a flaw in that although the court actually did impute $35,000+ of annual income to the wife, it never actually made it into the court's calculations. The second—
Mr. Korn, let me interrupt just to make sure I'm clear. Did the trial court ever make a specific finding on the former husband's net income?
No, Your Honor. We raised this at page 39 of our brief and was also raised expressly in our motion for rehearing. The court recited testimony from the husband's CPA, which indicated that according to his calculations, his net income was about approximately $20,500 per month. But the actual final judgment does not include any actual finding as to what the net income is, which of course is obviously significant. First, because there was a divergence between the opinions of the two CPAs who testified at trial. And secondly, because of this court's requirements that the trial judge make a finding as to net, because especially in this case, Judge Ray, gross income or income that's reported on a tax return is not wholly indicative of ability. As was discussed in great detail at the trial, Mr. Wottrell, who handles nursing home cases, is required to advance substantial amounts of costs to finance, whether it's expert witnesses or other litigation costs, which results in what is euphemistically referred to as phantom income. In other words, income that would be reported on your tax return, but is not actual cash money that's available to be spent, and whether for support for himself or support for his family. This is referred to in the Bear case cited in the briefs. So to answer your question, no, there was no finding of net, and part of the problem is because there were divergences between what Mr. Hand, the wife's accountant, testified to as to his income. There was, even in the final judgment, an acknowledgement that there was a $4,000 error where Hand says originally it's 37 a month gross, and then he says, oh no, it's really 33. That, coupled with the failure to make an actual finding, presents some real challenges to determine the reasonableness of this award. The second part, Judge, if I can just present this so it'll have some context, is the cumulative effect of all of the awards in this case: the permanent alimony, the attorney's fees, the equalization payment for equitable distribution, and the lump sum payment where the husband was required to pay the wife's post-petition credit card debt, takes us anywhere between 71% of his net income, if you believe Mr. Hand's assertions, or approximately 80% if you accept the assertions made by the husband's accountants. And we've cited the cases, Gentili, and all the other cases cited in our brief, which we rely on, which indicate that a percentage of a payor's income is simply excessive and constitutes an abuse of discretion. I would note one other thing, Judge, to your question about the failure of having the net figure. A detailed motion for rehearing was filed by the husband in this case. Sadly, Judge McCauley, who tried the entire case, presided over all, including the temp needs hearing and the trial, was unable due to health reasons to return to the bench. So the successor trial judge felt constrained by cases such as the Groover case, which we cite in our brief, to not address any of the issues in the motion for a hearing, but simply had to deny them. I would respectfully submit that had Judge McCauley been given the opportunity to have addressed some of these issues, I think many of them might have in fact been able to have been taken care of on rehearing. But we take the cases as we find them, as I know this court does as well.
Mr. Korn, I want to follow up on something that Chief Judge Ray asked about, how the order did not specify a specific monthly income for your client. And I understand what you're getting at there, but when I look at the alimony statute, it says that the judge has to require whether there's a need for alimony and whether the party has the ability to pay alimony. My recollection from the order is that the judge did in fact go through all of that. You're right. There's a lot of evidence about what his income is, and there was some disparity. But in the end, what the judge said is, you know what? Here is an amount that Mr. Wottrell has the ability to pay. In other words, it doesn't say in this statute anyway, I know that what the case law says, that they have to make an explicit determination to the dollar of the payer spouse's net income, just that they have the ability to pay. And it does in fact say that in the order. Why is that not sufficient?
Well, Your Honor, I would respectfully submit that frustrates the court's ability to provide full and complete review to the case. In other words, if we're determining whether the amount of the alimony award constituted an abuse of discretion, we need to know one of those key figures. And to simply have the court make a finding, well, I think he can afford to pay this, is nice, but it doesn't comport with what I believe the inherent goal of the statute is, and the inherent review function of this court, which is to be able to determine, in fact, what is net income in this particular instance. And again, as I mentioned earlier, this is a somewhat atypical case because although Hand says that Mr. Wottrell's income had been relatively stable, the cases are legion about plaintiffs' lawyers and the ups and downs of income, good years, bad years, and the like. That may have some bearing on the issues that counsel may raise in his cross appeal. But I think that is the problem here, Judge Winokur, and that's the reason why that deficiency presents a real reversible error as far as we're concerned. And again, when we look at what he may have had the ability to pay any of these particular components, but Gentile, which we cite in our brief, teaches us that the court should consider the cumulative effect of all of the obligations that the payor spouse is going to be required to make. And when you look at all of those obligations, including the amount that he'll be paying for the adult dependent daughter indefinitely, plus the amount he's paying for the youngest child's private school tuition, plus all those other obligations that I mentioned before, the equalization payment, the attorney's fees, the credit card, et cetera, it simply becomes too much of a burden for anybody to be able to handle. For those reasons, we believe that the court did abuse its discretion in the amount that it awarded. And again, we think that part of the problem was it accepted a CPA Hand's lifestyle analysis, which basically keeps the wife virtually in the lifestyle that she had during the marriage, while the husband is now in a nice but much smaller townhouse and is devoting a substantial amount of his income to maintain the former wife as well as the two daughters, the one dependent daughter and then the minor daughter. For these reasons, we think that this judgment does constitute an abuse of discretion. We recognize the deferential standard that this court gives to determinations of alimony amounts. In this instance, again, based on the various cases that we cited in our brief, and I won't go over them in detail, they're briefed substantially, I would submit that this does in fact create a situation where the load is just simply too much, whether we accept the numbers propounded by the wife or the numbers that were propounded by the husband. I see I'm into my rebuttal. I'll stand down at this point. Thank you, Your Honor.
Thank you, Mr. Korn. Mr. Grassley.
Thank you, Judge. Excuse me. we have started with the moving target of what is the former husband's income. And the reason I submit that the record shows unequivocally that the reason that there's no specific finding is because it kept changing. The temporary needs hearing, the court found his income for 2016 to be $505,000, in 2017, $524,000. Paragraph R of the final judgment recites what the has been reported to the IRS, the W-2 and distribution income to the former husband, which approaches $400,000 a year. That's paragraph R of the final judgment. There is no misunderstanding about what his income is. There is certainly obfuscation and muddy of the waters. He showed up, the former husband showed up at trial with his third amended financial affidavit showing, oh, I'm only making $270,000 a year now. So Judge Winokur, you hit it on the head. The statute requires the ability to determine whether the payor has the ability to pay. Mr. Hand's analysis, which certainly the court could have relied on for this instance, found that even after paying all of the expenses that the former husband was ordered to pay, and this is using after-tax dollars, contrary to the initial brief's assertions that we're using gross income rather than net income, which is false, and accounting for this $4,085 a month that showed up at the last minute as an expense for the oldest child, who is an adult dependent, that Mr. Wottrell still has $3,000 a month surplus, and that's after paying the funds to the former wife for support. Now let's talk about the imputation. The judge—
Well, Mr. Gross, let me ask you, what percentage of that, of his net income would then go to these expenses?
I can't calculate that, Judge. I'm sorry, this is a nightmare for me, asking me to do math at an oral argument, but—
Well, well, certainly the cases ask us to look at that percentage.
Absolutely, and one of the best
whether
cases—
alimony exceeds his ability to pay. And
absolutely, but he still, after paying the $10,000 a month to my client in alimony and paying all of his expenses, the record shows he still has $3,000 a month left over, surplus. That's paying his own expenses, paying my client's expenses. So it can't exceed 50%. I mean, just as a matter of general mathematics, there is no phantom income here. And I would encourage the court to look at 50 through 52 of our brief, where we've discussed that at length. There is no such thing. There is no income averaging here, which Mr. Korn alluded to. This is based upon his tax returns. I would say ironically, but consistent with what the final judgment did, Mr. Howell, which is Mr. Wottrell's CPA, testified that his 2018 income was greater than $350,000. I think it was 367, I mean. So the bottom line is there is sufficient record evidence to show that not only is there no problem with his income to be able to support both parties, but he's going to have a surplus. My client does not have a surplus, which gets us to the next question, the next issue raised by Mr. Korn, that, oh, they didn't impute the income to her. Now, I will admit that this final judgment is not a finely drafted instrument. They call Mr. Hand and Mr. Wiggins, both of whom are very respected experts in their field in Duval County Circuit Courts, and called them the wrong first names 2 or 3 times. So I accept that there are certain things that are not exactly accurate. It would have been better if the court had made a specific, I'm finding that the imputation will cover the expenses not covered by alimony, but we can infer that without any real question by just reading what the final judgment said. My client needs $11,500 a month just to be able to pay the extra additional cost, but I'm not going to order the husband to pay all of that because he's paying all this money for the oldest child and he's paying the private school tuition, which is to be treated as child support. So
how do we know that the trial court actually considered imputed income to her if the trial court did not specify it in its order?
The reason we know that, either that or the judge was completely lost, and I don't assume that. the real question, I mean, the real answer to that is look at what my client has been left to pay. She has no employment at the time of the trial. She's imputed the amount despite having been out of the workforce for 18 or 19 years, she's imputed $35,000 a year in income. And the judge has left her having to pay extra money for her credit cards that she ran up in order to support herself during the pendency of the case, because the temporary support was not enough. He's left her with $37,000 in credit card debt, approximately half of which was ordered as a lump sum payment. She's also has to finance her own car and her own health insurance other than a year worth of COBRA. And she also has to pay $65,000 in attorney's fees to her attorney. So those are expenses that are not being paid. And somehow the judge has figured that she's going to be able to pay them. And how is that possible on this record? That she's going to either make it up by the imputed income, which of course is not real. It's just an assumption that we make. But it means that she's going to have to go out and find a job to make those payments because there is no other source of income here. And so how do we know that he used the imputation? Because otherwise he's left her destitute and going into debt further every month. And that is the bottom line. I find it really ironic, Judge, that Mr. Korn used this failure to make a definitive statement of income as interfering with this court's ability to effectively review this case, because that is where I need to go now as to the cross appeal issues, which is the first one that I'd like to address so that I've said it, and hope we can get to the next one, which is that this $4,085 a month that the former husband showed up with in expenses for the oldest child that he's now occurring, which the court utilized in its analysis of his ability to pay alimony, had no record support. It was never testified to before. Mr. Korn said, well, he showed them their bank accounts and they could have parsed those and determined which one of these was for this child. Oh, he testified at the temporary needs hearing where he had $500,000 a month in income, that he had certain expenses, which he admitted he was not paying, such as childcare costs for her, since my client was providing that. The real issues on the cross appeal have to do with the failure to effectively evaluate the impact of the contingency fee cases that settled before the trial, and the failure of the trial court to make specific findings about why my client's fee claim was not reviewable. I mean, was not necessary for him to make fact findings about the fee claim. It was just enough for the judge to say, well, at some points, enough's enough. You can't bill for every second. Well, that's not what Rosen requires. And I know how much the court loves getting supplemental authority 2 days before oral argument, but the second DCA came out with a case on Friday that I filed on Sunday as supplemental authority that talks at great length about the need under Roe for a specific analysis of fees and hourly rates and fees so that you can make a determination of the reasonableness of a fee. We don't have that here. And in the minute and a half I have left, the trial court misunderstood what Mr. Hand's testimony was about the contingency fee cases. Mr. Korn wants us to say that what we're trying to do is take a post-filing asset and treat it as a marital asset. That's not correct. The asset is the case. The case was worked on that we're talking now solely about the contingency fee cases that were pending and were not settled at the time of the filing, but were settled prior to the trial.
All right, and so for those cases, though, and I understand the arguments below, are there any Florida cases that adopt the methodology that Mr. Hand used to determine marital value for those contingency fee cases?
The answer is no, but Judge, that's not the right question, because what Williams and
I'm
sorry, I got it that you don't
interest me the most.
No, I get it, but here's the problem.
That the trial court distinguished were for that reason, that those cases agree with the general principle that contingency fee cases can have marital value, but there has to be a methodology that's appropriate in determining that value. So I'm asking you, is there any case that provides guidance in that regard?
No, there is not. But you are right. Williams and Roberts established the principle, but the methodology used there was not discussed except to the extent that cases that had not settled were speculative. And we agree with that. What we're talking about now is cases that turned into actual dollars prior to the trial in this case that had been financed with marital funds and worked on with marital labor. It is completely erroneous to say, well, what Mr. Hand did was he just made it up. No, he didn't make it up. What he did was he provided what we used to call the CA analysis of the marital portion of a non-marital asset to come up with what he refers to as the coverture fraction. All he did was use the filing date as a cutoff for what portion of the contingency fee case that had produced income prior to the trial here. How much of that was marital, which was up to the filing date, and everything after that was treated as non-marital.
Right. So he treated each day as the same day in terms of marital value. And that is one way to approach it. But obviously, each day is not the same.
But that's only to calculate how long the case had been pending to determine, okay, if you had 300 days, 200 of them occurred before the filing and 100 afterwards. All that does is give you a way to calculate what that share would be. Let's look at the CA analysis, the analysis of attributing or determining a marital share of non-marital asset. What mattered is what the production, what the marital labor was during the course of the marriage. If this asset preceded the marriage by 10 years, then you cut off that 10 years and you start with the day of the marriage and you determine how much of the non-owner spouse had contributed. There's no difference here. It doesn't matter if the taxes or the maintenance or the improvement to the property happened all in one weekend or over a year. That was irrelevant, because what was relevant was the time period of the marriage is when you calculated the amount of the marital share. And that's all Mr. Hand did. Do I really only have 2 minutes and 30 seconds left for rebuttal? Okay, it's always the case, but I will reserve my time if I'm allowed. Thank you, Judge.
Thank you, Mr. Grassley. Mr. Korn.
Thank you, Your Honor. Let me just briefly touch on Mr. Grassley's argument about the expenses for the eldest child, claiming in his brief, and again today, this was some kind of an ambush. It's obvious that the requirement under the family law rules to amend and to supplement information applies to financial affidavits. It's hardly unusual for the parties to have filed a financial affidavit in the past and updated as of the time of trial. Moreover, his claim that there was no record support for the $4,000 plus that he was spending on her is rebutted not only by Mr. Wottrell's direct testimony at trial, which is obviously competent substantial evidence, but also by the entries in the financial affidavit, which just as to the KW expenses, which you will find, it's at Husband's Exhibit 11, starting at 935. Those expenses alone were about $3,600, not counting food, et cetera. So this claim that there was somehow no background or no basis for the child's expenses lacks any merit. Let's talk a little bit about this alleged marital function with respect to what Mr. Hand did. Judge Ray, your question was spot on, and there is no authority. The two cases that were referred to not only by Hand, but in the judgment, which the court found to be distinguishable, Williams and Roberts specifically note that in some instances, if there was a vested right to a certain amount, the court could, in its discretion, consider it. But there is no methodology, just such as what Hand admitted there was no methodology. I submit this would never pass a Daubert test, much less a Frye test. The Daubert opinion came out about a month after this case got tried. But Hand admitted the only thing he had was time. And time does, as Howard Coker, who was the husband's expert on this, testified, in personal injury cases and especially nursing home cases, you cannot value anything until the case actually either tries the verdict or settles. Cases that look wonderful go south. Cases that may look mediocre turn out great. That's the inherent speculative nature of it. What Mr. Wiggins, husband's expert, properly did was he considered, when evaluating the husband's PA value, looked at the contingency cases where there were actual offers made and used that as the basis, which that at least gives us some kind of a empirical, quantifiable amount that we can go to. Otherwise, the speculation is not how much the case might have been worth. The speculation is how much of the work that was done to bring that case either to verdict or to settlement was done post petition. And the cases, of course, are legion that the filing date is the bright line cutoff for determining whether marital labor enhances the value of a marital asset. Now,
but you would agree that there was some, quote, marital labor prior to the filing. And so what methodology do you suggest is appropriate for the court to determine the marital value of these cases?
I'm not sure I have the wisdom, Judge Ray, to be able to give you that. I can tell you what it isn't, and time isn't yet. The one thing that Hand was asked whether he did, which maybe he should have considered, was to actually look at the cases and say, okay, I mean, look at the Smith case, the Jones case, the Green case. Where are we in the case? Have depositions been taken? Are we set for trial? Have the experts been deposed? Hand admitted he did none of that. All he did was he counted days. And if you look specifically at page 1134 of the record, which is the wife's exhibit that Hand relied upon, there's even a chart that shows the number of hours spent on the case as of October 2nd, 2017, which was the filing date. And as Coker and as Mr. Wattrell both testified at trial, the number of days, and as the cases themselves say, the number of days is a red herring. There's no traceable relationship between when the time was spent and the value of the case. One of the cases, I think it was the Williams case, poetically said that the plaintiff's lawyer can work like Hercules, orate like Holmes, and reason like Cardozo, but until the case comes in, it's not worth anything. And so perhaps, Judge, if an expert actually were to look at the cases and evaluate each individual case, that might theoretically be a potentially appropriate basis. But Hand didn't do that. Hand acknowledged he didn't do that. And the trial court in this instance correctly found that the methodology was suspect and adopted the methodology used by Mr. Wiggins when he valued the husband's PA. The cases say that contingency fee cases are not CA-based. They're not amenable to some coverture factor.
Mr. Korn, if you could just briefly, in your limited time remaining, address the attorney's fee issue on the cross appeal. Arguably it does appear arbitrary without any factual findings to support it. So if you could respond to that argument.
You have to remember, Judge, that Judge McCauley had tried this case from inception. And he didn't just say, I'm not giving her fees. There are 2 pages in the final judgment where he addresses what husband had already paid to the wife's first 2 lawyers, $7,500 to one, $7,500 to another, $6,500 to her current trial lawyer, plus the $36,000 of the $50,000 that she already took from the home equity line of credit. And then the court specifically said, I've gone through each of these time entries. And there comes a point where zealous advocacy has to take a backseat to reasonableness. So when the wife asked for $130,000, the court awarded $65,000.
Right. And I guess for the same reasons you've argued that it's hard for us to meaningfully review lower courts' decisions without finding that we're kind of in that predicament too.
We sort of are. And I recognize the cases of this court and other courts that have talked about it. I would just submit, and I know I'm over time, so let me wrap this up. To do what Mr. Gressley would like to do in this case would literally take the 50+ page affidavit and require the judge to score it as if you were at a baseball game. Agreed, not agreed, rejected, accepted. I don't believe that's what 6116 requires. I don't think that's what the case law requires. I would respectfully suggest that you reverse as to the main appeal and affirm as to the cross appeal. Thank you, Your Honor.
Okay,
Thank you for allowing me to address that question.
Yeah, thank you, Mr. Grassley. And Madam Clerk, if you would please add additional time to Mr. Grassley's
Thank you.
argument. Thank you.
Judge, the last point first. Am I requesting and advocating that the judge have to keep a record like a baseball scorecard? No, I'm advocating that Rosen be applied. The case law is legion. This judge, yes, he sat there through this whole trial, but since when has that ever been a legal excuse for not doing the analysis that's required? I cited the 5th DCA case in Wright for the proposition that meaningful appellate review cannot be had without fact findings. And that's the exact same thing in the 2nd DCA case that I filed that came out Friday. It talks about the reason why we require this. So yes, that's the case. Getting to the methodology question, I had almost to laugh when Mr. Korn started talking about this being a red herring argument, because the red herring argument here is that these cases are legally worthless. That's a falsity. My first-year contract professor taught us that when we hear the word constructive, look for something that never happened. And so that's what we're trying to focus on here. We know, because the case is settled prior to trial, we know that they actually are worth something, and we know exactly how much they are worth. The methodology question is a case of first impression, because what Mr. Hand actually testified he did was he looked at Williams and Roberts and understood that he needed to, or he was authorized to, in intellectual honesty about what the value of the PA was, to value cases that had settled before we go to trial. And the difference here between Mr. Hand's valuation of the PA and Mr. Wiggins was $675,000. This is a significant issue. And if there's a question from this court about whether this methodology was appropriate, then send it back for a reconsideration under whatever methodology you believe is appropriate. But for Mr. Korn to say that a CPA is supposed to look at the actual cases rather than look at the length of time they were in the shop and when they settled, how much time had gone by. Mr. Watrell does not keep time records. He's a contingency fee lawyer. The only time he keeps time records is when there's an offer of settlement. And then you start scrambling to calculate and document your time so that if it becomes an issue, you at least have something to go on. But he works solely on a contingency fee basis. And so to claim that that's somehow a substitute for the use of time, I disagree on a theoretical level. But what Mr. Hand did do was consistent with Florida law. And this court, if you think that there's something else that needs to be done in terms of the methodology, tell us what it is and send it back, because this idea that a case is too speculative to arrive at any realistic value during its progress, as the final judgment said, we agree with that. The progress of the cases we're talking about are over. It's finished. The money has been received, and it's part of what was created by marital label or marital funds. And just for purposes of being able to say, I actually did it, I'm stopping before it hits zero. Thank you, Judge.
Thank you, Mr. Grassley and Mr. Korn. Thank you very much for your arguments today. This
Thank
case
you,
is
Your
now
Honor.
concluded.
Thanks.